Good morning to everyone. Before we proceed, I'm going to request that there be no outbursts during these proceedings this morning. During the course of this trial, everyone has conducted themselves very appropriately, and I appreciate it. And they acted appropriately with the respect of the court, and I can't tell you how much I appreciated it. But I will not tolerate any outbursts as I read this decision. If there's anyone from any of the courtrooms within the courthouse today that do not conduct themselves appropriately, I have instructed the bailiffs and the law personnel present to remove those individuals. I know many have questioned why I did not make a decision immediately. And so I thought it was really important that I explain that to everyone. Under Iowa law, the court in a bench trial is required to write a written ruling in a bench trial and come into open court like I am today to read that verdict. I could simply read the verdict and file my written decision. I've chosen not to do that today. I think this case, due to the crime involved, is very important and very, I find that it's appropriate that I read the entire decision today. In a 2-count trial information with the crimes of murder in the first degree in violation of Iowa Code Section 707.2 under count 1 and kidnapping first degree in violation of Iowa Code Section 710.2 under count 2. Murder in the first degree is defined as a person commits murder in the first degree when the person willfully, deliberately, and with premeditation kills another person. Murder in the first degree is a Class A felony. Kidnapping is defined as when a person either confines a person or removes a person from one place to another. Knowing the person who confines or removes the person has neither the authority nor consent of the other person to do so. Kidnapping first degree is defined as the act of kidnapping accompanied with the intent to inflict serious injury upon such person or subject the person to sexual abuse. Kidnapping first degree is a Class A felony. The defendant is presumed innocent and not guilty. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. The defendant has entered pleas of not guilty, which is a complete denial of the charges and places the burden on the state to prove guilt beyond a reasonable doubt. If the state has not proven the defendant guilty beyond a reasonable doubt, then the court must find the defendant not guilty. In considering the evidence presented, the court makes deductions and reaches conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. The court must decide the facts from the evidence. The court considers the evidence using its observations, common sense, and experience. The court will try to reconcile any conflicts in the evidence but if the court cannot, the court accepts the evidence it finds more believable. In determining the facts, the court may have to decide what testimony to believe. The court may believe all, part, or none of any witness's testimony. In determining what testimony to believe, the court considers the reasonableness and consistency of the testimony with other evidence, and internally, whether a witness has made inconsistent statements, as well as the witness's appearance, conduct, age, intelligence, memory, knowledge of the facts, interest in the trial, motive, candor, bias, and prejudice. The burden is on the state to prove the defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case, or from the lack or failure of the evidence produced by the state. If the court, after a full and fair consideration of the evidence, is firmly convinced of the defendant's guilt, then there is no reasonable doubt and the defendant should be found guilty. But if after a full and fair consideration of all the evidence in the case, or from the lack or failure of the evidence produced by the state, the court is not firmly convinced of the defendant's guilt, then there is reasonable doubt and the defendant should be found not guilty. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily. Not by mistake or accident, the court may, but is not required to, conclude a person intends the natural results of his acts. Specific intent means not only being aware of an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires the court to decide what the defendant was thinking when an act was done. It is seldom capable of direct proof. Intent may be shown by circumstantial evidence and the reasonable inference drawn from the evidence. Therefore, the court should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. Facts. On July 10th of 2020, Breasia Terrell was reported missing. It was not until March 22nd, 2021, that she was found. On that date, her remains were found in Clinton County, Iowa, near a pond south of the Kunow implement dealership. Prior to her disappearance and death, Breasia knew the defendant, Henry Dinkins. Her mother, Aisha Langford, had a relationship with the defendant, and as a result of that relationship, her mother had a son named DL. Breasia and her brother were only 2 years apart and therefore were very close to one another. The defendant was involved in the lives of Breasia and DL, but not on a consistent basis. Recently, before July 10th, 2020, Aisha had discussions with the defendant, encouraging him to be more involved in his son's life. As a result, plans were made for the defendant to spend time with DL on July 9th, 2020. On July 9th, 2020, the defendant went to the children's grandmother's home to pick up DL. While there were discussions between the defendant, the children's grandmother, Breasia, DL, and their older brother, CS. During those discussions, it was DL's desire to have his sister, Breasia, come with him, and his older brother, CS, said he would like to come as well. The defendant approved Breasia to come along, but did not approve the older brother, CS, to come along. Although the children's grandmother did not give permission for Breasia to accompany DL during the visit with his father, Breasia did leave with DL and the defendant. When Aisha returned from work, she was informed of the events when the defendant picked up the children. She then gathered clothing for the children, which included pajamas for the evening and other clothes to change into, and then proceeded to the apartment where the defendant resided with his girlfriend, Andrea Culberson. When Aisha arrived at the apartment, Breasia came to the car to collect the clothing, and she was excited to see her mother and their dog, their family dog. After the defendant took the children into his care, they proceeded to the home of one of his friends. At that home, the children played video games and other games with the children in the home while the defendant visited with other adults at the residence. They then proceeded to the apartment located in the Jersey Meadows apartment complex in Davenport, which the defendant shared with his girlfriend of 6 years, Andrea. The apartment occupied by the defendant and Andrea was a one-bedroom apartment, which was accessed by a single exterior door that opened to a staircase entering into the open apartment located on the second floor of the building. The one bathroom in the apartment was located off the bedroom. Also within the bedroom were 2 closets, one used by Andrea and the other used by the defendant. While at the apartment, DL played video games in the living room area of the apartment, and Breasia played video games and interacted with Andrea while she worked remotely in the bedroom. The children were provided dinner, then showered and readied themselves for bed. The children did not put on pajamas provided by their mother for bed, but were each provided defendant's large white t-shirts size 4XL to wear to bed. The children were allowed to sleep in the bed in the bedroom, and the defendant and Andrea were going to sleep on the air mattress in the living room area. Breasia fell asleep first, then Andrea, and then soon after DL and the defendant. At some point in the early hours, DL felt his sister Breasia kick him, and in a statement to police remembers seeing her leave with the defendant. Subsequent to that, at 3 o'clock in the morning, Andrea awoke to use the bathroom. At that time, she noted the defendant and Breasia were not present in the apartment. She had not been told that the defendant left, nor that he had taken Breasia with him. She was very concerned about the situation and decided to stay up in the living room in the dark to wait for the defendant. She realized his phone was not charged, so Andrea placed it on a charger. At approximately 3:30 a.m., Andrea heard the defendant open the door to the apartment very quietly and proceeded up the stairs very quietly, as if not to awake anyone. When the defendant arrived, he did not have a conversation with Andrea. Even though she had tried to speak with him, he would not interact with her. While at the apartment, the defendant went into the bedroom and retrieved something from his closet, which he had exclusive use of, and Andrea was unable to see the object retrieved. The court finds that the defendant either retrieved the gun used to kill Breasia or another item to facilitate his murder of Breasia. The size of the revolver retrieved from the pond would have been easily concealed. Prior to the defendant leaving the apartment, Andrea looked out the window and saw Breasia in the large white t-shirt she had worn to bed next to the maroon Chevy Impala. When the defendant pulled away in the vehicle, Breasia was no longer there. The defense argues there is no one testifying they saw Breasia in the Impala. Although this is true, the court is relying on its common sense and experience that if Breasia did not go with the defendant, then she would have entered the apartment or knocked loudly to gain access to the apartment. Breasia was not familiar with this complex. If she was not with the defendant, she would have wanted to be with her brother and Andrea. The defendant then traveled to a quick shop on 53rd Street in Davenport. While at the quick shop, the defendant purchased $35 worth of gas, cigarettes, and a lighter utilizing a $100 bill. The evidence establishes the gasoline purchased was sufficient to fill the tank of the Chevy Impala he was operating. During this time at the quick shop, it is evident the defendant is ensuring that Breasia remains in the vehicle while he is inside the store. From the quick shop, the defendant then traveled to the pond located in Clinton, Iowa, which is south of the Kunow implement plant. This pond is located in the intersection of 218th Street and 270th Avenue. It is at this pond that the court finds the defendant willfully, deliberately, and with premeditation killed Breasia by shooting her 3 times. The defendant then, in the process of leaving the area, became stuck off the side of the road. He then walked to US 61 and flagged down a vehicle driven by Jared Brink. Brink then proceeded to drive the defendant back to the area where the Chevy Impala the defendant was operating was stuck off the roadway. Brink then removed the vehicle utilizing a chain. The defendant offered Brink $100 for his help, which Brink refused. These findings by the court are overwhelmingly supported by all the evidence provided by the state's witnesses, particularly the brave testimony provided by DL. And his statements to law enforcement. Additionally, the testimony of Brink offered through his discovery deposition and his statements made to police. All of this was further supported by the testimony and statements made by Isha and Andrea. Their testimony and statements were corroborated by the investigative efforts of the Davenport Police Department and the FBI, except for the testimony of DL, stating that he saw his father shot Breasia. The court finds his testimony credible. His testimony is supported by the subsequent investigation by the Davenport Police Department and the FBI, and additionally by his videotaped interview with the police after the disappearance of his sister. This court finds it remarkable that an 8-year-old child is able to communicate with the police with such specificity to allow the Davenport Police Department to begin their investigation. DL explained to the officers he was on a dirt road with his father, and there was a hill which went down towards the water. Additionally, DL stated when he was with his father, the defendant explained he had earlier become stuck, and he was with some fishermen. They pushed him out, and he offered them $100. DL tried to explain the area he was with his father, which included seeing tractors, water, and a hill down to the water. It was not until later this statement is corroborated by subsequent discovery of Breasia's remains. The court finds beyond a reasonable doubt DL was present in the area while he was with the defendant. FBI Special Agent James McMillan took soil samples in the area where Jared Brink pulled the defendant from the shoulder of the road. Those soil samples were compared to soil samples obtained from the undercarriage of the Chevy Impala operated by the defendant. FBI forensic geologist examiner Ian Sagadorn determined 3 of the samples taken from the area concentrated where the Chevy Impala would have been stuck were inclusive to those soil samples taken from the undercarriage of the Chevy Impala operated by the defendant. Brink came forward after the news of Breasia's remains were discovered, and there's no doubt in this court's mind whatsoever he identified the defendant as the operator of the Chevy Impala which he removed from the shoulder of the road, and that he identified the vehicle removed from the shoulder of the road, that being one operated by the defendant. Brink identified a very distinct characteristic of the defendant's face, which was a mole on the right side of his face by his nose. The white aux cord located within the vehicle, and the shorts worn by the defendant at the time he had made contact with him. All of this evidence proves beyond a reasonable doubt the defendant had Breasia Terrell within his control. He was at the site of her remains, and he was the only person who shot Breasia that early morning of July 10th, 2020. The defendant, after being pulled from the shoulder of the road by Brink near the pond located by Kuno Implement in Clinton County, Iowa, then returned to the apartment he shared with Andrea in Davenport around sunrise. When the defendant arrived at the apartment, Andrea was surprised to see the defendant in a different set of clothes. Andrea testified when she fell asleep, the defendant was wearing a white tank top and colorful shorts. When he arrived back at the apartment, he was in a white t-shirt and blue shorts. Upon his return, he took DL with him. Before he left with DL, Andrea insisted the defendant take his cell phone with him. Even during this time, no discussions were had that Breasia had disappeared. The defendant then traveled to Walmart, located in Clinton, Iowa. At Walmart, his only purchase was 2 bottles of Clorox bleach. The defendant, on the way back to Davenport, stopped at the pond located at the intersection of 2018th Street and 270th Avenue in Clinton County. It is unclear whether the defendant may have stopped at this location on his way to the Clinton Walmart, but it's beyond a reasonable doubt the defendant did stop there after making the purchase of bleach at the Walmart in Clinton. DL clearly described this area in his statements to the police and by his statements of his father wiping off a large knife with bleach. DL's testimony and statements regarding this portion of the activities of the defendant are clearly supported by all the investigative evidence presented by the state. Cell phone records of ping notifications of the defendant's cell phone are non-existent until DL places the battery back into the defendant's phone at the Walmart in Clinton. The testimony from the various officers of the Davenport Police Department and special agents of the FBI were credible as to their findings of the cell phone being disabled or dead when the battery being placed back into it, and the pings were registered on the various cell towers. The fact the defendant's car was equipped with an auxiliary cord to charge the cell phone further supports the court's finding that the defendant was taking actions to avoid his whereabouts being traced by his cell phone pinging on cellular towers during his travels. The court finds DL's testimony as to the smell of bleach while the defendant was wiping off the large knife, which the evidence indicates was the machete, very credible. There was bleach purchased, and the court finds it reasonable that such substance was used at the time of wiping the knife and would have been used in the area in which Breasia's remains were recovered. DL's testimony and statements are further corroborated by the fact the officers investigating this case had no knowledge of why the defendant's cell phone would have pinged in the area of Clinton Walmart. It is only due to DL's statement that he placed the battery back in his father's phone to play a game and then took it out upon his father's return from being in the store. This information led to further investigation as to the defendant actually being in the Clinton Walmart and purchasing the bleach. At the time of DL's statements, there was no knowledge of purchase of bleach. Additionally, after DL identified the knife as the machete in the exhibit shown by Detective Hammis, there was no knowledge of such machete prior to the discovery of the machete in the defendant's RV. Although machete did not reveal DNA or fingerprints, it is clear to this court it had been wiped off because there were fibers within the serrated edge of the machete. Then again, after leaving the area of the pond, the defendant traveled into Davenport and traveled in the area of his motorhome in Credit Island. Clearly, he placed the machete, which had been in his trunk, into the motorhome. The defendant called Aisha at 8:08 a.m., telling her that he had just woken up and Breasia was missing. Although prior to this time, he had been driving all around Clinton County, and at that time of the call to Aisha, he would have just been entering Davenport as he was seen traveling south on Highway 61 at 7:52 a.m. He was then in the southwest area of Davenport and near Rockingham Road, near his motorhome in Credit Island. He did not leave that area of southwest Davenport until approximately 8:26 a.m. During all of this time, there was a series of telephone calls and text messages between the defendant and Aisha. During these exchanges, the defendant advised Aisha he was traveling to the Davenport Police Department to make the report of Breasia's disappearance. Aisha then left her place of employment at Checkers on East Locust Street in Davenport and headed to the police station. It was at this time Aisha was traveling west on Locust Street to the police station. She noticed the defendant heading east at a high rate of speed. She then turned around to follow the defendant and caused him to stop at the McDonald's at Eastern Avenue in Kimberly. Around this time, Aisha made contact with the Davenport Police Department and determined the defendant never appeared at the Davenport Police Department, and the request was made that she and the defendant proceed to the Jersey Meadow apartment complex. They then proceeded in different vehicles to the apartment complex and met with police officers who responded to the initial investigation of the disappearance of Breasia. Upon her arrival to the complex, Aisha was the first individual to meet with responding officer Craig Burkle. Officer Burkle advised both Aisha and the defendant he would like to search through the apartment to ensure Breasia was not hiding within the apartment. Immediately, the defendant stated she's not there and they had looked everywhere. The defendant took Officer Burkle up to the door of the apartment. When approaching the door to the apartment, the defendant knocked, which was odd since he occupied the apartment with Andrea. Andrea answered the door, was very hesitant to allow the officer in, and only allowed him in after it was confirmed the defendant consented to the officer searching the apartment. Officer Burkle then searched the apartment. Of course, Breasia was not located within the apartment, but upon Officer Burkle's return outside, the defendant was nowhere to be found. Subsequently, Officer Burkle called the defendant's cell phone at least 6 times within an hour's period and then texted the defendant. There was no response from the defendant until he called Officer Burkle upon his entering the police station at approximately 12:00 p.m. The defendant's whereabouts were unknown for a period of approximately 3 hours. Through cellular tower pings, it was determined the defendant had traveled to his sister's home on approximately 3 occasions, which is supported by cellular analysis. It is important to note that the defendant had changed his clothes from the early morning hours from the white tank top, blue and pink shorts, and gold shoes into a white t-shirt, blue shorts, and still gold shoes. And then upon his arrival at the police station, had different tennis shoes on, which were blue and white. Search warrants were executed for all of the vehicles, the apartment that the defendant shared with Andrea Culberson, and the home of the defendant's sister. At no time were the white tank top, pink and blue shorts, or gold shoes ever recovered at any location. They were nowhere to be found during the entirety of this investigation. Shortly after noon, the defendant was then interviewed by the Davenport Police Department. During this interview, the defendant was extremely evasive as to the location of the Chevy Impala. He was very evasive about his whereabouts. He stated at various times that he had been looking all over Davenport for Breasia and that he had no knowledge of where she was at. He made no statement to the officer that he was with Breasia at 3:30 in the morning and gave no information about the fact that he had traveled all the way to Clinton, Iowa with DL. He also indicated to the officer that he had traveled to his motorhome to get money in order to purchase gas. Court finds a statement by the defendant completely untruthful, as he would have had sufficient monies from the change he received back from his purchase at the Quick Shop. He had $100 to offer Brink, and most notably, in Exhibit 6-16, the officers located approximately $5,000 in $100 bills in the search of the Chevy Camaro, which was operated by the defendant and had ability to access. The only truthful statement the defendant made during his interview with the police was that he went to the Quick Shop. The court finds none of the statements that the defendant made during the interview to be truthful in any respect. The court finds beyond a reasonable doubt the defendant was the last person seen with Breasia. He had taken custody of her, had no authority to do so, and removed her from the apartment from which he had authority to care for her, with the specific intent to inflict a serious injury upon her, knowing that he did not have the consent or authority of Breasia or her mother to do so. And as a result of that removal, Breasia suffered death, which is clearly a serious injury. The court finds beyond a reasonable doubt that Breasia was shot by the defendant and that she died as a result of being shot. And the defendant did this act with malice aforethought, and the defendant acted willfully, deliberately, and premeditatedly with all the specific intent to kill Breasia. All this occurred on or about the 10th day of July, 2020, and the criminal activity began in Scott County, Iowa, and the defendant's criminal activity continued as he traveled into Clinton County, Iowa. The court finds beyond a reasonable doubt that the remains located at the pond at the intersection of 18th Street and 270th Avenue are those of Breasia as a result of the testimony of the forensic anthropologist, Dr. Heather Garvin, and the medical examiner, Dr. Kelly Cruz. Matthew Dean and David Baker were both inmates at the Clinton County Jail while the defendant was being held pending trial in this matter. Both of them credibly testified during the airing of a news story concerning the disappearance of Breasia. The defendant made this statement: "They are never going to find her." Both of these witnesses are credible, specifically Matthew Dean, who was no longer being held on any criminal charges, and David Baker testified he was not receiving special treatment in regards to any pending criminal charges in exchange for his testimony. Therefore, neither of these individuals had anything to gain from their testimony. Specifically, David Baker testified when he heard the defendant make the statement, he took the statement to mean the defendant knew where Breasia was located. The court found every witness who testified on behalf of the state to be credible in their testimony. As noted, the only testimony the court did not find credible was that of DL, as to him being present and seeing the defendant shoot Breasia. The court's credibility findings are appropriate as statements were consistent between all the witnesses and were corroborated by the investigative efforts of the Davenport Police Department and the FBI and all other agencies. Again, it should be noted all of these investigative efforts would not have been fruitful had it not been for the information provided by DL. DL was instrumental in solving the murder and kidnapping of his sister Breasia. The court specifically finds the defendant was not savvy in any manner. The defendant did not account for the statements and testimony of DL and that of Jared Brink. The evidence provided by these two witnesses clearly, and all the other witnesses, undermined every effort which the defendant may have taken to be savvy or calculated in his actions to avoid being charged and prosecuted for the kidnapping and murder of Breasia. Ruling and verdict. Count 1, murder in the first degree. The court finds the state has met its burden of proof in this case. The court finds beyond a reasonable doubt the defendant committed murder in the first degree. The court finds beyond a reasonable doubt the defendant acted with malice aforethought and willfully and premeditatedly and with the specific intent to kill Breasia Terrell, shot her on July 10th of 2020. And as a result of being shot, Breasia Terrell died. Thus, the defendant is guilty of the crimes of murder in the first degree. Accordingly, the court, based on the testimony of the witnesses and review of the exhibits offered in this case, finds the defendant, Henry Earl Dinkins, guilty of the offense of murder in the first degree in violation of Iowa Code Section 707.2(1)(b). Count 2, kidnapping first degree. The court finds the state has met its burden of proof in this case. The court finds beyond a reasonable doubt the defendant committed kidnapping first degree. The court finds beyond a reasonable doubt the defendant removed Breasia Terrell on July 10th, 2020 from the apartment in which he was caring for her with the specific purpose of inflicting serious injury upon Breasia Terrell. The defendant knew he did not have the consent or authority of Breasia Terrell to do so, and as a result of that removal, intentionally subjected Breasia Terrell to serious injury, that being death. Accordingly, the court, based on the testimony of the witnesses and a review of the exhibits offered in this case, finds the defendant, Henry Earl Dinkins, guilty of the offense of kidnapping first degree in violation of Iowa Code Section 710.2. It is therefore ordered and adjudged and decreed that the defendant, Henry Earl Dinkins, is guilty of the offense of, under count 1, murder in the first degree in violation of Iowa Code Section 707.2(1)(b), and guilty under count 2, kidnapping first degree in violation of Iowa Code Section 710.2, as contained in the trial information filed by the state of Iowa. It is further ordered an informal pre-sentence investigation report shall be prepared by the 7th Judicial District Department of Correctional Services. The PSI shall be electronically filed by noon 3 days prior to the date of sentencing. It is further ordered sentencing in this matter is scheduled for October 11th at 1:30 in the afternoon. It is further ordered the defendant is being found guilty of forcible felony shall remain in the Scott County Jail pending sentencing without bond. Thank you.
And we have the guilty verdict at last. Let's see. Has Law and Crime left the feed yet? Let's go over and see some more victory. It'll be a little early for, the family's still celebrating in the courtroom, so I would expect that WQAD is going to be outside waiting to talk to the family, and I'm sure they'll be wanting a chance to express their relief and gratitude. This is finally over. I didn't catch what they said, but there will be articles spelling it out, I'm sure. So I will probably do a follow-up after the families had a chance to speak and so forth, and we'll put it on the calendar. October 11th. Okay. I missed it. Okay. It looks like they are done over. Let's see. Oh, yep. They're going to another thing over there on Law and Crime. So, October 11th, I'll put that in the calendar, and we'll definitely tune in for watching the sentencing, because the family very much deserves a chance to speak their mind, and I want to know if there's anybody who is going to be trying to speak for old Dinky, because I don't see he didn't really look like he had any supporters in the courtroom. So, very good, very good. I was nervous when it was taking so long for the judge to come up with the verdict, but then I realized that he's already in jail for violating parole and failing to keep his address as an RSO current. And so it wasn't like they were in a hurry to read the verdict, because it wasn't like he was going to go free that day. The day the verdict is read, if he was acquitted. And I'm so relieved that the judge came to the conclusion he did, because with the lack of physical evidence, it was a little worrying. But the fact that they couldn't even find fingerprints and so forth for Dinky in his own car, that was very telling. It's a good question. He if you want to go back and take a look, when he first started talking about DL, his voice broke, and he kind of had to take several seconds to compose himself before going on. And I think he was thinking just how how brave DL was in being able to, tell what he saw and so forth, because not all kids are that good at that. So, yeah, a very good day. And so it'll be October 11th. If I happen to be doing another trial at that point, we'll take a break from that for the sentencing. I've been wanting to do Sarah Boone, Suitcase Sarah, Suitcase Girl, because that case is so outrageous. She just got her 7th attorney. The trial's supposed to start in October. I'm not sure what day in October, and I'm not sure if it's going to be delayed because of her getting yet another attorney. And it could be a way, her keep ditching attorneys might be a way of postponing the trial, because she knows that's going to happen. And I think the judge isn't going to be very sympathetic for her if the relationship breaks down quickly. So, but if we are doing Suitcase Sarah or another trial, let's see, what have we got here? Okay, just a text. Yeah, so October 11th, I'll put it on my phone so that we little miss it. Yeah. I mean, who plays hide and seek by putting the person that you're supposed to be seeking in their hiding place? I mean, that may work for a 2-year-old, but adults, really? So, okay, well, I guess we'll wrap this up and see what's coming up soon. And yeah, I mean, her whole story, oh, I thought he would let himself out of the suitcase, I had no idea he was still inside. Well, duh. So, okay, well, have a great weekend, and I may possibly do another video later after we get some news. Yeah, flip the suitcase over, so he can't open the suitcase that way. So okay, well, I'll see you soon. Hopefully we'll have some good news reports coming out with the conviction, and we'll see you soon. Bye-bye.